Hi, I am Carrie Gold. I'm the Director of Litigation and Policy at the Eviction Defense Collaborative in San Francisco, California. We are the lead agency for San Francisco's right to counsel law, we only do eviction defense and rental assistance at our agency. But we work with 9 other nonprofits, and I oversee the work of all of the 9 nonprofits doing the right to counsel in eviction cases work. Before we get started, I want to apologize for not covering every county and every city's laws in the state of California. You will see I've picked some counties to reference throughout this training, and I caution you from the get-go to check each county's COVID-19 eviction-related moratoriums, and because they are constantly being updated, and then also individual cities within those counties may have even stronger protections, so you do need to check those as well. First, I want to just give you a lay of the land regarding evictions in general. In January 1st, 2020, AB 1482, which was codified at Civil Code Section 1946.2, created statewide just cause eviction. And it also created statewide rent control. I'm not going to cover much about the rent control parts of AB 1482, since this training is geared towards evictions and COVID-19, but suffice it to say that under AB 1482, the rent increase limits are 5% plus CPI, but maximum is 10% per year. Now for just cause eviction, it applies where a tenant has resided in the unit for 12 months. However, if there's more than one tenant, all tenants must have resided for 12 months, or one of the tenants has to have resided for at least 24 months. It also only applies to units that are over 15 years old. This is a rolling date. So every year, another year of units comes under the jurisdiction of this law. So currently it takes you to 2005. There are certain units that are exempted. You'll find those exemptions at Civil Code Section 1946.2, paren E, paren. The list is on the slide, but I'll just point out certain things that you would expect wouldn't be covered by just cause eviction or rent control are there. Hotels, hospitals, extended care facilities, dorms, but some are a little less intuitive. Shared housing where the tenant shares with the owner, single family owner occupied where there are no more than 2 units rented. That may not make a whole lot of sense, but some people do own a single family home, but they have an in-law unit, and sometimes they rent a room in their house. But if they rent 2 rooms in their house plus an in-law unit, then they would be covered. A duplex where the one unit is owner occupied as the owner's principal residence at the beginning of the tenancy, and the owner continues to occupy the unit. Let's see. Under the eviction controls, there are different grounds for eviction that are permissible. You should check if your jurisdiction has its own rent control ordinance that is stronger than Civil Code Section 1946.2. I can tell you right now that the San Francisco rent ordinance is much stronger than the law, the state law. The Oakland rent ordinance is stronger. The Santa Monica rent ordinance is stronger. The West Hollywood rent ordinance is stronger. So you do want to check your local ordinances. Under the state law, there are certain causes that we call no fault that a landlord may evict for. The owner moving in, but only if the tenant has agreed in writing or it was in the lease that the owner has the right to do this type of eviction. An Ellis eviction, which is a state law, which allows a landlord to withdraw all units of a building from the rental market. This law is governed by, it's in the government code. I'm sorry, I don't remember the section, but there is special requirements to this type of eviction that are governed by the government code, including the fact that an Ellis eviction requires a 120-day notice of withdrawal of the unit from the rental market, and it requires recording the withdrawal of the units from the rental market. There is an automatic extension if there is a senior or disabled to a year before the evictions can begin. But it is one of the just causes, no fault just causes, that is permitted under 1946.2. Also, the intent to demolish or substantially remodel the unit. Also, the owner complying with a government order to vacate, such as a red tag because of conditions in the building. The prerequisites to I need to go back because I skipped my just cause fault slide. These are the obvious grounds for eviction that Civil Code 1946.2 permits: non-payment of rent, breach of lease, nuisance, waste, failure to sign a lease that is substantially similar to the previous lease, criminal activity, subletting in violation of a lease. These are the typical eviction actions that you will see anyways. All the things that you think a tenant can be evicted for, they can be. These are the fault ones, and the no fault ones we covered. Prerequisites to evict. The landlord, if it is a curable violation, must give notice and an opportunity to cure. This is Civil Code Section 1946.2, paren C, paren. If the tenant hasn't cured, then the landlord has to serve a 3-day notice to terminate the tenancy. Under the no-fault evictions, the landlord is required to pay relocation. Relocation is 1 month of rent or that the landlord pays, or the landlord waives the last month's rent. The landlord must give notice of the relocation rights, and the relocation must be provided within 15 days of service of the notice. The landlord must give written notice of just cause rights, and Civil Code Section 1632 translation requirements apply. So that means that the landlord, if they negotiated the lease in another language, they have to use that language when they give these notices. Again, be aware that local rent control jurisdictions may have stronger relocation requirements. For instance, in San Francisco, the amount that must be paid is in excess of $6,000 per person. It maxes out at 3 people. 50% of it must be paid at the time that the notice is served. The rest is paid when the tenant leaves. There are additional payments for seniors, disabled, or children in the home. So you do need to check your local rent control ordinance, if there is one, to see if the relocation benefits are greater than those under Civil Code Section 1946.2. So currently there are no evictions for non-payment in most California counties. What do we mean about non-payment? It's specific to non-payment due to or arising out of a substantial decrease in household or business income that was caused by the COVID-19 pandemic or any government response to COVID-19. And for the most part, tenants will need to provide written documentation of this income loss. What does a substantial decrease in household income mean? It would be income loss due to caring for a family member with COVID-19, if your work closed, if there were layoffs or furloughs, or job loss, reduction in hours at your job. You have to miss work because your child's school closed or your daycare closed, or some type of compliance with a government health authority order. Substantial decrease in business income would be if there was a work closure or reduction in opening hours, reduction in staff reporting to work, reduction in consumer demand, compliance again with government health authority orders. So for instance, currently, while we're taping this, restaurants are still not allowed to be open, bars are still not allowed to be open. So that would be compliance with a government health authority order that created a substantial decrease in the business income of the business owner. How do you notify your landlord? Both types of decreases in income must be substantiated with written documentation or other objectively verifiable proof of the same. There are 2 counties in the Bay Area that have an exception to that, and that's San Francisco and Alameda. They do not require that there be a writing and documentation, but we would still recommend that tenants do so. San Francisco's law only changed on April 30th to not require the written documentation. So for tenants who were impacted financially by COVID-19 before April 30th, they had 30 days to give their landlord notice that they were impacted financially by COVID and give that notice in writing to the landlord. The writing under the state law, the writing must be provided within 7 days after the rent is due. This is for the general state protection. This would be if the county that you're dealing with didn't provide its own protections. There is still some protection given by the state of California. So I'm going to give you some examples of different counties about how to notify your landlord. In Contra Costa, a tenant must give notice within 14 days of their inability to pay the rent. In San Mateo, the tenant's notice to the landlord is triggered by the landlord serving notice of the county order, and the tenant then has 14 days to respond to having received that notice. In Sonoma County, there's no deadline to give the notice, but if notice is given, the landlord cannot serve the 3-day notice. In Santa Clara, this notice can be given to the landlord anytime before judgment is entered. Let's see. I also wanted to mention federal law before we move on with more California, because you may be representing tenants who live in HUD housing. And under the CARES Act, an eviction moratorium was put into place from March 27th through July 25th. Now, this is not, during that period of time, if a tenant's unable to pay their rent, the landlord may not begin the eviction proceedings. At the end of that period, July 25th, if the rent remains unpaid, it is not forgiven under the federal law. So, but the landlord must serve a 30-day notice to the tenant, requesting the tenant to make the payment before they can go forward with an eviction action. The federal government under the CARES Act also eliminated late fees during the time that the moratorium is in place, March 27th through July 25th. And this is not this law applies to properties with federally backed loans and Section 8 voucher choice programs and public housing, and most project-based Section 8 housing. It is the National Housing Law Project on their website does have a list of the federal housing this moratorium applies to, and you should check there. However, they also have websites that you can check whether to help you figure out if a property is covered by a federally backed loan. One thing that you can advise tenants in federal housing to do is to help them with this unpaid rent is to seek a interim recertification, because their rent is based on their income. And so the rent can be lowered if they have lost income, but they must apply for an interim recertification. On the rent repayment plan, California state law only extended the time to file an eviction action and said nothing about repayment. So there wasn't a lot that was done at the state level, or hasn't yet happened, to help tenants. Different counties have enacted rules with regard to the rent repayment. So far, there's none of these laws, again, forgive the rent. It's just a way of how will the rent be repaid. In San Francisco, it's my slide is now incorrect, and this is why I say you'll have to check all the time. But it's 6 months from the termination of the mayor's executive order, and the last executive order of the mayor's was the 12th executive order that was issued on April 30th. So that means tenants will have until December 30th to repay this unpaid rent. Now, it only applies to the unpaid rent during the time of the moratorium. So when the moratorium gets lifted, if a tenant can't pay the next month's rent, they could be facing an eviction action for that month's rent, but it would not be inclusive of the months that they didn't pay during the moratorium. I know that sounds confusing. In Alameda County, they are giving 12 months to repay after the missed payment. Marin County did not allow a repayment plan. So as soon as their moratorium lifts, the landlord can seek to collect the unpaid rent, and that would be after May 31st. Contra Costa, it gave 120 days after May 31st to pay back the unpaid rent. Sonoma County gave 60 days after the end of the local emergency to pay back the rent. And because the date of the local emergency could change, I have not put that in there. That's something you would have to check. In San Mateo, it's 180 days after the expiration of the emergency order to pay back the full amount of unpaid rent. This is actually done in part. So it's first, the tenant has a 90-day time limit to try to pay it back in, but the tenant can give further notice that they were unable to pay it back in that 90 days and get another 30 days for the next 3 months. But in those, so the last 90 days of that 180, the tenant has to give notice each month that they need more time. In Santa Clara, the tenants have 120 days from the termination of the ordinance, which is currently May 31st, to pay it back. The time will only be extended under state law or local law or amendment of the ordinance or the town or the county's ordinances. The Judicial Council was really quite generous when it finally met to deal with the emergency and issued on April 6th in order that courts may not issue a summons or enter a default in eviction cases until 90 days after the governor declares that the state of emergency is lifted or amended or repealed by the judicial council. There is an exception to this rule, and that is the cases where eviction is necessary to protect public health and safety. In those cases, the housing courts or your local court must have some type of hearing or ability to have a hearing for the landlord to be able to obtain a summons. And the landlord will have to show that the eviction is necessary to protect the public health and safety, and that is what the judge will have to weigh to determine whether or not the judge will allow a summons to issue in that case to begin immediately. For the cases that had begun before the judicial council set its rules on April 6th, and where a tenant had already filed a first appearance, the court may not set a trial date earlier than 60 days after a request for trial is made. Now, aside from the non-payment cases, many jurisdictions instituted eviction moratoriums in other cases. Now, the state did not do that. So this is jurisdiction by jurisdiction. Again, check your county, then check your city to see if they have instituted such a moratorium. In San Francisco, all but Ellis evictions and health and safety exception cases for 2 months after the order expires. And that is my date there, July 22nd is not correct. The order expires July 30th. And Alameda, all but Ellis evictions and government orders and health and safety exceptions. And this runs for 90 days from March 24th. Marin limited their eviction moratorium to only the non-payment cases due to financial impact from COVID. Contra Costa has an eviction moratorium for all cases except for health and safety and owner move-in through May 31st. San Mateo is through May 31st, except for health and safety, and I think it's owner move-in. Sorry, my slide cut off. The effect of violations of emergency orders. Some jurisdictions have specifically stated that a violation of the emergency orders can be pled as an affirmative defense in unlawful detainers. This is true in the orders from San Mateo, Sonoma, Contra Costa, Alameda, Santa Clara, actually, I believe San Francisco has now added that in their April 30th order. Again, this is one where you do need to check your county and local city ordinances to see if it was stated explicitly in their orders. However, even if it isn't stated explicitly, you should plead it as an affirmative defense, because more than likely a court will accept this as an affirmative defense, even if an ordinance did not specifically specify that it would be an affirmative defense. Some jurisdictions also allow landlords or allow people to sue their landlords for violating the orders. Alameda, Contra Costa, San Mateo, Santa Clara, Sonoma, and some of these do contain treble damage provisions. So check that out, because if you do need to send a letter to a landlord who's harassing a tenant about not paying, you do want to know whether or not you can let them know what violation of the order could do. Now, on this repayment, a lot of landlords are asking tenants to sign agreements to repay the rent. And we are recommending that you should not have tenants sign repayment plans. Many of these come with waivers, releases, claims that there's no habitability defects in the unit, and there is no need to sign a repayment plan, because the law of each county and each city provides the amount of time the tenant has to do that repayment in, and the landlord cannot begin their eviction case until after that time has run. Under the federal law, I mentioned late fees cannot be charged for the unpaid rent during the moratorium period. And in some local jurisdictions, they also do not permit late fees for the unpaid rent during the moratorium period. These include Contra Costa, Alameda, Marin, San Francisco, Santa Clara, and San Mateo. This is another one where I remind you to check your local jurisdiction to know what the rules will be. So when do we expect this eviction tsunami? I don't think we're going to be able to avoid it altogether. But you know, due to the judicial council rules, even in the non-payment cases, summons will not be issued until 90 days after the governor's emergency order expires. We're still not sure when that is. So my estimation is sometime probably in August. And that would mean that landlords can finally get their summons and start those cases. The non-payment cases due to financial impact from COVID will not be able to be filed until each jurisdiction's repayment period has concluded, if the tenant notified the landlord of the inability to pay. And so those cases, like for instance in San Francisco, there's a 6-month repayment period. This takes you out till December 30th. So those cases won't start until really after the first of the year. Alameda County did 1 year to repay. The other thing that Alameda County did and so far I think they're the only county that has done this, but they have said that the rent that was unable to be paid during the crisis may not be the subject of an eviction action. A landlord may still seek to collect it in a breach of contract action, but it will be treated like regular consumer debt. And that was instituted in Alameda County. San Francisco currently has some proposed legislation which will be heard by its land use committee on May 18th, I believe, or 17th, and then it would have to go out to the general board, which could happen the following week. If it passes, it would be something that could potentially become effective sometime in late June. However, those are the only 2 jurisdictions I know of that is doing that. So for everybody else, these eviction actions won't start until the time period to repay is over. Again, the health and safety cases, the exception that the judicial consult permitted, are currently active, and there's nothing that will stop those cases from going forward. But in my mind, there's a question as to when those cases will actually be able to be heard, because as long as you have requested a jury in those cases, and until the courts have figured out how to have a jury trial with social distancing, these cases may just go on for quite a while. I'm going to try to give you a very quick crash course on eviction defense. You'll probably have a lot of questions. Sorry that this is not live for you to be able to ask. But in an eviction action, it's a summary proceeding, and under the CCP 1161 et sec, the first response to an eviction action is due 5 court days after service of the complaint. And you can respond, it's just like any other civil action, with a demur, a motion to strike, a motion to quash, and finally an answer. It should be noted again that even in non-payment cases that are currently filed, but that got filed after April 6th, they won't be able to get their summons to serve the complaint until the judicial consult allows summons to be issued again, which, as I predict, will be sometime in August. And so that's when those cases can begin. Do not, if you are representing a tenant, do not say that you will accept service of the summons and complaint. Part of defending an eviction is the constant buying of time. Time is your friend, but is the landlord's enemy. They want to recover possession of their unit as quickly as possible. In eviction actions, there is, again, just like any other civil action, you may do discovery, and all of the discovery tools are available to you: interrogatories, requests for permissions, requests for production of documents, depositions. But everything is done on a shortened time frame. So if the discovery is served personally, then the tenant has 5 days to respond. This is not 5 court days, this is 5 days. There are judicial counsel form interrogatories for unlawful detainers, and they are useful because they do ask a lot of questions that you sort of need to get answers to. So if you're in a real hurry to get some discovery out, go and download those judicial counsel form interrogatories and check the appropriate boxes if you don't have time to draft your own interrogatories. But you are not limited to using those. The general form interrogatories, some courts do allow people to use those in housing court, and some do not. In San Francisco, they are not permitted to be used, except I think the court will enforce a motion to compel on 17.1. That is, if they sent a set of requests for admissions, they could serve the one that asks for any denials, the facts of those. Motions to compel are also done on 5 days notice, so it's always fun. You're never bored when you're doing UDs because things go very quickly. And even in the jurisdictions that did not require a tenant to have furnished documentation of the loss of income, it would be a proper area of discovery for the landlord. You might have to seek to, ask for a protective order if a landlord is getting too invasive into the tenant's privacy rights. I personally do not believe that it would include getting to see a tenant's retirement plan funds or full bank account, so you're going to have to balance the privacy rights of your client against what would be, the right of a landlord to know, was this person actually financially impacted by COVID? In trials, like I said before, you always do want to ask for a jury trial. You want to make this demand when you file your answer. The statute requires that a trial be set within 20 days of the landlord's request for trial. But with the judicial counsel emergency rules, currently that has been extended to 60 days. This obviously will delay your trial date, and currently, I would say indefinitely, or at least until the courts can figure out a way to hold a jury trial with social distancing, as I said before. Use the facts of this uncertainty of how long the delay will take to get to trial as a bargaining tool. This is why it's really critical to seek a jury trial, because you will be able to use it in your negotiations to help you get rent waived, if a tenant is going to give up possession, to get more time for a tenant to give up possession, and also to get a longer period of time if your tenant's going to stay and try to repay the unpaid rent. So it's very, very critical that you always make a demand for a jury trial, especially now because of the delays that it will provide you. When you do go to trial, I've listed out here sort of the things you need to bring with you. It's, again, no different than any other civil trial. You should come prepared with a trial brief. You should have subpoenaed your witnesses. You should come with some proposed voir dire questions. You should bring your exhibit list and all your exhibits. You should have your evidence chart. I always say have witness folders, so everything you need for one witness is in one place. You should have a jury verdict form along with jury instructions. You have to have your motions in limine ready, and if you've served notices to appear, you should have those, and a statement of the case. The jury instructions for UDs start at, I think, 4,300 in Casey, but you often will need to write special jury instructions. And some of the special jury instructions you will need to write are on waiver, any additional requirements to evict that are imposed by local or federal law. You may need to write one on retaliation, because retaliation there's both a statutory retaliation, Civil Code Section 1942.5, but there is also common law retaliation, which is much broader than Civil Code Section 1942.5. And if you don't find yourself falling within Civil Code Section 1942.5, you do want to then plead the common law retaliation. If it's a rent control jurisdiction, you want to modify the Casey burden of proof, because the plaintiff has the burden of proving that their dominant motive for the eviction is the grounds that they stated in the notice. Motions in limine do not have their origin in statute, but rather in case law. But they can make or break your case. These are really important. I have had so many cases that have settled as soon as motions in limine have concluded and settled in my client's favor. So they really can make or break your case. They're really important. If you're running out of time, which happens a lot when we represent tenants, I don't like to say this, but your motions in limine are more important than your trial brief if you only have time for one. Landlord attorneys do rely heavily on motions in limine. Common ones that they try to bring in are to exclude habitability evidence because the tenant failed to provide actual notice to the landlord. Actual notice is not required. Constructive notice is sufficient. They'll often try to prohibit evidence of retaliation defense in a non-payment case, because under CC 1942.5, you can't use a retaliation defense when you haven't paid rent. But again, that's where you need a trial brief or an opposition to the MIL explaining common law retaliation. In cases involving retaliation and discrimination, landlord attorneys will make a motion to shift the burden of proof regarding the plaintiff's dominant motive from the plaintiff to the defendant. They'll also seek to exclude evidence of other property owned by the plaintiff. They'll ask to exclude any evidence that the defendant will become homeless if evicted. Common motions in limine that a defendant may bring are to exclude evidence of behavior allegations that are not included in the notice, exclude evidence that was not turned over during discovery, exclude evidence of rent alleged to be owed before or after the notice period, and if this is not a non-payment case, and exclude evidence of prior unlawful detainers, exclude evidence of criminal convictions. So those are the general motions in limine. And that concludes my basic training on eviction defense and non-payment during the time of COVID-19.